2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
Well, hello. Good morning, everyone. How are we doing? I wanted to upload this video one more time with my commentary because I had done it. Oh gosh, I put this one together. This was one of my earlier videos. And because YouTube made me change a bunch of stuff on my channel, I ended up having to add a bunch of videos, which most of you know, with commentary. So before I add this one, I thought I would let you guys know that this one is the day that he just lost it. And I truly believe that when Judge Darrell said, frankly, I'm scared, or frankly, he scared me, whatever it was, I think she just did all that for the record. But let's see, because this is a good day because he gets so frustrated.
And just so I'm clear, because I was trying to get to that, what witnesses are here? Because I don't have any paperwork for Kohler. I don't know.
Douglas Kohler, Stephen Guth, and Erika Patterson. Of those three, I expect you to call one of those witnesses.
And don't you guys love how he knows all about the witnesses that he's called himself?
I accept for value in return for value this document.
For the record, Judge, Attorney Witchow just handed to the defendant for his benefit the police report as it relates to the statement of Douglas Kohler, since he's claiming he does not have it.
Since I know that I don't have it. So let's make that record correct. Who's supposed to come in 10:30, right?
Call your next witness, please. I don't have that list right at my fingertips.
You said what happened?
I don't have that list right at my fingertips, but I know there's a witness available, so please call your next witness.
You say what happened?
That 10:30 list.
Please call your next witness.
And who determined this order?
Mr. Brooks, I'll take up that issue outside the presence of the jury later. There is a witness available. Please call the witness.
That's not the witness that was intended to be called at this time.
I understand that, sir. Under 90611, I have the authority and the discretion on that, so please call the witness who's available.
So I'm being rushed to judgment.
No, sir, I'm trying to have an effective and efficient use of all of our time, so please call the witness.
Which is respected, but at the same time, being this is my time to present my defense. I'm going to excuse the jury
for right now. I'll rise for the jury, please.
Also didn't provide me with that list.
You were advised on the record,
but
sir.
you didn't provide it to me.
Sir, you chose not. That's on you, not me.
Nah, that's
so.
No, you
here's
can't.
The
that's
thing.
A rush to judgment.
Erika Patterson is here, so I'm advising you that she will be the next witness that you call if you so choose. If you choose not to call her right now, then I'm releasing her from the subpoena.
At the same time, though, that's still a rush to judgment, Your Honor. You can't. I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses.
You did not want to provide us with the order, and I respected that, Mr. Brooks.
But I said that.
And
from the
so
beginning.
then I asked
Your
you
Honor,
to put him in blocks.
with all respect, did I not inform Your Honor in the court that I would not give a specific order? I stated that numerous times.
And Mr. Brooks,
numerous
I
times.
have authority to tell you otherwise. You may not like it. You may disagree with it.
It's not about that. It's about the rush to judgment, Your Honor.
You have not been cooperating with this process. The
there's
state
nothing
has
to cooperate with.
agreed to assist you given your custodial status.
Okay, and I never asked them to do
any
that.
Attorney in this situation
I never asked them to do that, Your Honor.
Would give us the order.
Did I not? Did I ask them to do that? I did not ask them to do that. They volunteered.
They offered.
So at the end of the day,
but we expect
if
your
they didn't want to do it,
in that.
yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor. Let's
No, common courtesy is the stipulation.
Okay, that's a rush to judgment.
There's no rush to judgment here. You
Did
keep
the
saying
state
that, sir,
have to
but
put
that's
their
not the
witnesses?
case.
Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did.
Did they have to do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did not.
I didn't have to
do
be
it.
provided with, we're gonna call this witness at this time,
But they're
and this
able
witness at this
to
time.
contact
They
their
didn't have to do that, so why should I have to
and
do that?
accommodate their schedules. This is not about you, it's not about the state, it's about the witnesses'
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with
So here's the
with a shock
situation.
device
It is
on my ankles.
9:52.
So how's I'm trying to control anything?
I'm
I just
Chocolates.
want this
I'm
to be
going
fair,
to-
and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair
Explain to
because
me how
of
that's
the
fair.
process that it has been set up to frankly help you get
No,
the
it's not
witnesses
helping me by,
to
it's helping
court.
the state
And no.
by being able to say, if we know the time and we know
You
the
did
person
not-
and we
I
know this,
asked you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I
Whole
would have
aim of
had you
that.
come in later. You didn't want to answer that question.
There was no
And
question there was no question to answer.
That's not
I
true.
did what you asked me to do, Your Honor. You
No, you
said
didn't.
yes, you did. You did. You asked me to give them my witness
Mr.
list.
Brooks,
I gave them my
yesterday-
witness list. It's not
Yesterday,
my fault.
I very
It's not my fault they
expressly-
wasn't gonna be prepared to do their
Here's the
to
deal.
do
The
their
jury's
cross.
coming out,
They're
and
not
I'm
prepared.
going to stand my ground on this.
I'm gonna
Okay,
stand my
it
ground
is-
too, but I'm
if
not
you
gonna
don't call
be
her-
disrespectful or disruptive.
If you
I'm just
don't
stating I
call
want it to be
her,
fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For
Law-
your
where's
lack
the
of
lawful law?
cooperation.
Where's the lawful law? I have the right to
You have to
witnesses,
cooperate with this process,
but I
sir.
also have the Sixth Amendment right.
We have a witness available for you to call. I can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That didn't
in the
have a
order.
time. That didn't have a time or of
I'm not going to
or an
play
order.
this game with you, sir.
It's not no game. That's what
was-
you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game. I don't take this as a
asked-
game. That's what
explain
nobody.
this to you
That's what
once
nobody.
again.
You don't gotta explain nothing to me.
Do you want?
That's what you don't understand. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
It is
some things in the
unfair.
ship
It's
that's going
unfair
on.
and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a
What
joke.
type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So I
understand.
think, Your Honor, with all due respect, I think you should show
we're
some
gonna take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in
No,
recess.
you're not rushing me to judgment. I don't care what you're talking about.
Thank you, everyone. Please be seated. The defense may call its next witness, please.
Give me 1 second. I'm trying to make sure I got the paperwork since I'm being rushed to judgment.
Go ahead.
Defense calls Erika Patterson.
All right, thank you. We'll have her brought in.
Since I'm being rushed to judgment.
Rush to judge.
I'm just gonna start the questioning. I'm not seeming to find paperwork that I just had on the table for some reason, odd reason. It was reported there was in fact no incident on November 20th, 2021.
That's not true.
Objection, move to strike the answer and the question.
Grounds.
Lack of personal knowledge, hearsay.
Sustained. I'll strike the question and the answer for the reason stated, sir, rephrase, or
So can I show the witness the same paperwork that I attempted to show?
no.
And why not?
Not relevant.
He doesn't want to be shown up
How's
in
it
front
not
of
relevant
Erika.
when that was just testified to? Wouldn't that be opening the door?
No. Next question.
So to the best of your recollection, you can't recall why an alleged incident on November 20th of 2021 was reported to never happen.
Objection,
Grounds.
Same reasons as the previous objections.
Seems facts not in evidence. It's characterized as her prior testimony and irrelevant.
I object to that respectfully and
Next
ask for a
question.
legal finding of fact and a legal reconsideration of that ruling, Your Honor.
Denied. Noted for the record. Next question, please.
I'm trying to figure out how something got pulled out of thin air. Interesting. So it would be fair to say that you have a child in common with the alleged defendant. Would that be fair to say?
Yes.
Yeah, is that the only child in common?
Yes.
You have any other children?
Objection.
Grounds.
Has nothing to do with the case. Sorry.
Hold
I'm
on,
so
there's
young.
been an objection. Not relevant. Sustained.
Grounds for the sustain?
The record speaks for itself. Next question.
What was the record speaking for itself? I didn't hear it.
Not relevant.
How is it not relevant?
Next question, please.
How is it not relevant? The child that you have in common with the alleged defendant, how old is that child?
15.
Do you keep regular contact with that child?
Off and on.
Describe what you mean by off and on.
I'll object.
Grounds.
This is not relevant.
Not relevant. Sustained.
Grounds.
It's not relevant, sir.
She answered it.
Next question, please.
And the child in common that you have with the alleged defendant, does that child live with you?
No.
Objection.
Grounds.
Relevance.
Grounds.
Sustained. Not relevant. You don't have to answer that.
Do any of your children live with you?
Objection.
Grounds.
Relevance.
Sustained.
Ugh, that face he gives her
Grounds for the sustain?
Not relevant.
drives me nuts.
That goes to the credibility, Your Honor, so how is it not relevant?
The objection has been sustained.
For relevancy. I object to that and would like to inform you that I intend to appeal that decision unless you want to give a legal reconsideration of that ruling.
Noted for the record, I direct your attention to 906.16, and the basis for the objection being sustained is it does not fall within the categories listed. Next question.
Is that lawful law?
Next question, please, sir.
I'm getting there. This is lawful law.
Wisconsin State Statute 906.16.
That doesn't answer my question, but okay. Where did you meet the alleged defendant?
Reno, Nevada.
How long have you known the alleged defendant?
16 years.
In relation to the alleged incident on November 21st of 2021, would it be fair to say that there's been no contact between you and the alleged defendant?
Not since then, no.
That last answer was kind of low. Did you say no?
I said no, not since then.
Such an asshole.
So that would mean, assuming, that would mean no contact at all via phone or anything like that.
No.
So my question would be,
Here we go.
I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state. The bailiff will take them.
Get him,
It's not
Zach.
proper procedure, sir.
I'm going to object to those being shown to the witness. They have no relevance whatsoever to this trial.
Yes, they do. And
Sustained.
I'm getting to how they had relevance.
They've also never been disclosed to the state before this moment.
Sustained.
Sustain why?
Not relevant.
They are relevant. It creates foundation. And I can prove that.
I'll take up the issue outside the presence of the jury at the conclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well. You stated that there's been no contact. How would the alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Assumes fact, not in evidence.
Grounds.
Sustained. Assumes facts not in evidence, not relevant.
How's it not relevant? Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence,
No,
and at this
facts.
point,
I got the pictures
conduct
right here.
after
Facts.
the alleged date of violation here is not relevant.
Alleged violation.
You're correct. After the date charged, the
With
dates that are charged.
tons
for
of
these
evidence.
allegations, you are absolutely correct.
Thank you. Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Nope.
Objection.
Grounds.
Relevance.
Grounds.
I'm going to excuse the jury.
He said
All
relevance.
rise for the jury.
Look at the way he stares at her. Such an egomaniac. Imagine how many times she had to endure the abuse from him and the way he looked at her.
When did you receive this document that you claim was sent by this witness?
It's not claimed, it's for a fact.
Sir, it hasn't been established yet. I need to make a
So
record.
do y'all want
I
the
wanna
letter?
see
Y'all
the
want the
letter.
envelope? What?
I want to see the letter.
Okay, so I gotta.
And I wanna
so now
know
I gotta
when you
bring that
received
in.
it.
Now I gotta bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and I
Okay,
want
well,
you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks,
Come on, man.
Stop.
when you
Stop
aren't
Stop
even
it.
letting
You're a
me
public
ask the
servant, Your
questions.
Honor. I respect your courtroom. I
You
respect
do.
you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to in
man.
count 77. Okay. The
And
state-
what happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
there's
need to
nowhere
make
to
a
be found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
Okay,
sir.
whatever.
So you're doing it once again.
Whatever. Just make your record. Does the letter read?
You have the letter. You showed it to me, sir.
I tried. Yeah, and I've been trying to find it ever since I came back in, and now all of a sudden I can't.
And now
find it.
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you interrupting
yes, you may.
me?
Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't
You
say you.
implied it, sir.
But did I say that?
You stated it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said, I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone out, though.
And like,
I
well,
don't
that's
think that
kind
that's
of
fair.
interesting.
I don't
I don't
think that
have a
that's fair to
document that was
assume.
just on my table. That is what you said.
That's
Words
what
to
I
that
said, but I
effect.
did not point the finger at anyone.
So,
I
you
can see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue
Sit
with the
down
record,
and
sir.
shut up.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My
Your
guess
Your
is
Honor,
maybe
with
to
all respect-
simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object.
Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. I think I can clarify the record momentarily when I'm done. That you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't, I referred to this one because this one had the pictures. But
And why do you
the
believe
one,
it was from
to
Ms.
answer your
Patterson?
question, to answer your question with clarity,
Thank you. Does it have a date on it, the letter?
no, I didn't bring the letter, I brought the pictures. Because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness
We need
knows
the
that
letter.
they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that.
I
Oh,
don't think
no, I
she's
still
ever
love
said
you.
she was
Oh,
afraid. I
ooh,
think that was the officers who may have stated that, but I don't believe she
But-
ever said that. She specifically said today when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes, and she said, I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm gonna ask you, even if this letter's from her, these pictures are from her, how does it
Your
relate to
Honor.
her credibility before the
Who
jury?
else could who else could these pictures be from?
Your mother.
I'm gonna ask you point blank, did you get a letter that's signed from her?
I got What do you mean sign? No
How
one
do you know?
signs letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erika Patterson?
Because they were sent from Erika Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was
Are
it the
you-
content
are you
of the
kidding
letter?
me?
No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on the limb here.
And I'm asking you why you hold that opinion.
I'm gonna go out on a limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is gonna when you
You're
say
not
to me,
answering my
when
question,
you say to
sir.
me,
What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else.
This is,
You gotta answer my question. It's
Your
called an
Honor,
offer of proof.
But you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to
Why
lay
would
a
I not know?
foundation for these letters, sir. That might be
This
through
is
your own
ridiculous.
testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff
Are
about
you
I'm in jail
serious?
and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. I need you to
Because
answer.
they're from her.
But you're assuming
Like,
that.
how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal
The
term
bottom
or
line is I
something?
need the letter. So if you're gonna question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not gonna allow any questioning without having that letter.
So
The
what
state
about-
has the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here.
There is no letter
So-
from her.
I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with
So-
you in court?
I just said no. How many
Okay.
times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And
yes,
everybody
we can
assumes-
hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic.
Because
you try
it's not a
go
tactic,
off of
it's
what
facts.
we're talking
It's
about
facts.
to some other reason.
It's facts.
to
Because
some
I
other
find
thing.
it hard to believe that
I'm gonna
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm gonna let the
Come on,
state
man,
make a
stop.
record of why they
Stop.
believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
This is great.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erika Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let
that.
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erika Patterson is a bad mom. I think that that's what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erika Patterson when she was a minor in Nevada for doing so, he was convicted of statutory sexual seduction, pled
Yes.
guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So
Bam.
if there's any causation that would lead to Erika Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the
finish.
end
I'm
of the
not
day,
done. I love it.
If we're gonna open the door on that, no, since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can open the door
loud,
on how old she told me she
disrespectful,
was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the speaker
No, that's
finish.
not. I'm not going to sit here and let somebody be inaccurate on the record and lie on the
All
record.
right, under Illinois versus Allen, I've warned him repeatedly, he's being removed from the, unless he brings that letter and he
Don't
can
sit
show
there and try
it
to
is
think you know what's
inadmissible,
going
she
on.
will not be questioned, and under 90611, I will
You gonna
declare
talk
the
about what
cross-examination
you don't know where,
closed.
You don't know where, what
Thank
happened
you,
at
we're
the
in
time when
recess,
all this
1
happened,
hour.
bruh. Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much.
Push that
Did you
button,
know
didn't
she
he?
said she was 18 when I met her? Did you know that?
So for the record, I think it's important to note that the two photographs the defendant attempted to show that witness and presumably put into evidence depicted what I believe to be the defendant and Ms. Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born around May 1st of 2022. I'll make an offer of proof that Ms. Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to Dawn Woods, the defendant's mother, long day, who then, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She didn't write one on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her Waukesha County Jail on 37 occasions. She has never accepted a single one of those phone calls. And finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
Bam.
Thank you, I appreciate the record being. Let's take up the issue of the letter and the photographs and your offer of proof, sir, if you have one.
I don't need no offer of proof.
I'll ask you a second time, do you have an offer
We
of proof
can
to
go
provide,
past all
sir?
that. We can go past all that. I don't need to ask them questions. It's too much of an issue. It's too much of a problem.
Mr. Brooks, I'm gonna ask you for a third time, do you have an offer of proof
I
related
just
to
said
the
no. I just said no. I just said that.
All right, thank you, then based upon there being no offer of proof, then,
You
my
got
decision
busted.
stands. As to the continuation of the examination of Ms. Patterson, I would like an offer of proof as to what you believe her probative and relevant testimony will be from this point forward.
I mean, I don't know how she's going to answer the rest of the questions. There's not that many questions left. I was almost done.
What topics generally were you going to question her about?
I guess I'll have to look in here because so much that happened since over the past hour and a half or so. I can tell you one thing. I don't intend to have too many more questions. I tell you that. I was almost finished.
I need an offer of proof as to what you believe her testimony would be, meaning what topics?
I wanted to ask questions about the police reports. That was the last few questions. That's why I'm saying it was only.
Is it a statement that she wrote?
I don't know if it's a statement that she wrote in here. Possibly is.
Do you see a written statement with her signature
I will
on it?
have to go through all the paperwork.
Is there a written statement from Ms. Patterson? It's my understanding Detective Guth spoke to her on both occasions, is that right?
Yes, with Detective Barrett with him on the first occasion. Detective Barrett wrote that first report. Both interviews were also recorded.
Previously provided with discovery. What about the police report, sir, do you want to question her about, so I know with specificity?
The report is not in order, so again, as I stated before, I would have to read it.
Mr. Brooks, I trust that you're prepared. These are your witnesses. So what questions, what about that report do you want to question Ms. Patterson on?
Your Honor, I just stated 3 times I would have to read a little bit of this to form the questions.
Under my authority, under 906.11, then, and given that this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that time, and they had ample time this morning to question her. I will declare that his questioning of her to be closed.
Man, I object to that ruling too. Can you give me a lawful law why?
Your objection is noted for the record. If you start interrupting me when the jury comes out or make any commentary, you will be removed to the other courtroom, and that's,
So I'm being held in contempt again?
no, it's not contempt, sir. It's a finding under Illinois versus Allen. It's a warning that you will forfeit your right
So I
to
might
be
as well just
present.
I might as well have just
No
stayed over
such
there.
contempt finding.
I might as well have just stayed over there then if I was
Mr.
gonna get held in
Brooks,
contempt.
that decision is for you and you alone to make, and it is based on your conduct. If you're gonna
Just
continue.
take me over there. Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did.
You're
You're attempting to hold me in contempt. That's what that is.
No, that's not contempt.
So is it civil or criminal? Why am I being
Mr.
held in
Brooks?
contempt?
Potential as to a witness by the name of, he has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to
of
be
the-
said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
I love watching
Brooks.
Leslie.
I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
This
Come on,
is
man.
to
Come on,
benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record
voice.
of.
Stop talking.
Come on, man. Like I don't know who y'all be thinking y'all fooling. I accept the value in return for value. This document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell?
I
Can you
believe he
explain?
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
He got called on the carpet. He's not used to getting called on the carpet. He's not used to being able to prove his lies, and he can't prove his lies. And he can't handle it. He can't handle the fact that he's an SA and that they brought it up because Zach totally pushed his buttons on that one. And then the whole fact that he thinks he can sit there and say that she's been calling him and contacting him. And then Zach was able to say, yeah, no, he's attempted to contact her 30 something times and she's not answered or not responded to him and has not spoken to him since November of 21st. I love it. I love it. I love it. I love it. So this is probably one of my favorite days because even though he was able to overstep his boundaries with Erika, that part really irks me. But at the same time, at the end of the day, he looked like an idiot. And, well, he looks like an idiot every day, but, I mean, he really was called out. I mean, there's no question. I love this one. Anyway, I hope you guys enjoyed this. I hope that I know I played this on a live one time, but I've never actually put it out there by itself since I had to do commentary on it. So, you guys have a blessed day. Stay safe, and I will talk to you soon.